We have only one case on the docket today, Anderson Paving Systems versus, Asphalt Paving Systems versus Anderson, Columbia, and State Department of Transportation. Is the appellate ready to proceed?
Yes.
You may. You may.
Good afternoon, Your Honors. It is a pleasure to be here, and I'll start momentarily, but first I want to thank the court for granting my motion to appear pro hoc, as well as my adversary's consent to same. Much appreciated. I'd also like to reserve 3 minutes for rebuttal argument. Now to get down to the fun stuff. Normally I would start with standing, but I think it's important here to address what we're actually here for. That is, what are the questions at issue at this point? We believe the sole question at issue is the denial of our petition based on a lack of standing, arising from 2 issues. 1, an alleged lack of substantial interest, and 2, the argument that this petition required a contractual determination by the FDOT. We disagree with both. Now, in terms of that standing issue, I think the FDOT has taken the position that, 2 things. 1, we didn't timely challenge a decision that they had made regarding the merits. That is, that this is basically the same issue that the subsequent contract, the second contract that we are challenging, the supplemental agreement, is basically encompassed in the maintenance contract, that work is one and the same, and therefore it is a valid supplemental agreement. Well, we're not there yet. The initial argument today is just whether we have standing to address that argument. And on that issue of standing, I think it's clear that the standard of review is de novo. And that has been conceded by Anderson, Columbia, and conceded for the most part by FDOT, except for that issue as to their determination that this work is encompassed in the maintenance contract.
To help us understand our analysis, it would be your position that to determine standing, you would simply look at the 4 corners of your amended petition and nowhere else? Is that your position?
Yes, Your Honor, and I think that's validated by the Keystone decision.
So no matter what the DOT says, Anderson, Columbia says, we simply look at the 4 corners of that amended petition, and if that amended petition within those 4 corners establishes standing, substantial effect on your client, that's a good enough thing to entitle your client to a final hearing?
There is case law that talks about inconsistent pleadings, or pleadings obviously bereft of factual support. This is not such a case. The pleadings here are consistent, and we believe properly state that we have standing, a cause of action, that what they did is outside their statutory authority. So yes, I believe if properly pled without inconsistencies or obvious errors, yes, I believe that's what the law requires.
And the basis of that is the decisions from this court, starting with our 2010 decision?
I think Keystone and Fairbanks both make it clear in that regard, particularly Keystone.
And one follow-up with your answer to my second question, you would concede it would not be a good enough thing to simply give conclusions in a petition. You would need some level of ultimate facts to substantiate those conclusions in order to establish standing?
I think a wholly conclusory pleading would be problematic. I don't think ours is wholly conclusory. What we've pled is that there was a maintenance agreement, a supplemental agreement. The work in the supplemental agreement that they're doing now is outside the scope of the maintenance agreement.
Ultimately, what remedy are you looking for here?
Well, at this juncture, as the work has been done, I think it's 2 things. 1, under 337.11.9, the statute says that such a contract, if impermissible, if it shouldn't have been a supplemental agreement, can be voided and payments stopped. In this case, we'd be looking to retract, call back that payment. The state shouldn't pay for work that was illegally let. And I guess the second thing we're looking for at this point is recoupment of our attorney's fees.
But that would not be appropriate regarding Anderson Columbia, would it? If they've done the work because the department determined it was a supplemental agreement. I know we're going down the road here, and you don't need to worry so much about that yet, although it is relevant, I think, to, okay, attorney's fees, that's fair enough, but that money can't be clawed back from Anderson Columbia for the work done through no fault of their own, right?
Ironically, I've had this case with Anderson Columbia several years ago in Florida, where my client had an unlawful contract led to them, and they did in fact have to pay the money back
After doing the work.
after the work was completed. There was a settlement of that case. It wasn't fully adjudicated.
And now we're way off the record, so
Yeah.
I'll stop there. But,
But yes, there can be a clawback. It's an illegal payment by the state.
so your remedy here is, aside from that issue then, the issue would be, getting a contractor who's done the work to give the money back to the state, and your attorney's fees in litigating whether or not you were entitled to a hearing in the first place?
Yes, Your Honor. And I would note, just to address the...
And I'm not blaming you for that strange state of affairs. We denied a stay that you filed.
And I think that's important. That's what I was just about to note. It's not as if Anderson went into this not knowing what the risks were. The record is replete with us saying, this is what we're going to do, this is what can happen to you. Numerous emails, and they
So let's-
chose to go forward.
Going back to the critical issue, your argument is that there has to be a 12057 hearing for the administrative law judge to decide whether this is a supplemental agreement, or a supplemental contract.
Whether it fits within the lawful supplemental
That's a
agreement
question of
paradigm.
law, right?
Excuse me?
That would be a question of law, right?
It actually involves fact as well. One has to look at the contracts, determine the actual work that was done. There's allegations in this case about rumble strips and, micro surfacing and also milling and paving. So one has to look at what each of these types of work are and make an assessment of the facts of whether in fact this is the same work that was in the
Well, let me ask you
maintenance
this, what
contract.
kind of supplemental contract do you think would be permissible under 337?
Well, I mean,
That
there's
would
a-
not allow for a point of entry.
There's a number of exceptions under 337.9B. One good example would be, and this is a maintenance contract,
Right.
and let's say actually in this one, or a great example would be, this is something Anderson kind of fed to us. Anderson gave us a statement that said they did the rumble strips under this contract. Now, we've gone back and looked, and actually Anderson did install the rumble strips, but they weren't under this contract. That's what we believe and have pled. So let's say this had been the contract under which they did put the rumble strips in, and the rumble strips didn't work. They were problematic. They needed to be eradicated, removed, or in the case of microsurfacing, kind of smoothed over. FDOT came to them and said, okay, now we want to do this. So that would be an appropriate maintenance contract. It's within the scope of that initial contract. It's the work that was contemplated. Now
You
you're
mean an
remedying that
appropriate
work.
supplemental contract?
Excuse me?
You mean an
A
appropriate
supplemental contract.
supplemental
Yes.
contract?
The supplemental contract, the concept is that it's part and parcel.
So is
of the
every
project.
question about every time the Florida Department of Transportation issues a supplemental contract, anytime a third party such as yourself that didn't bid on the original contract can come in and say, no, we want a 120, you want us to say this, we want a 12057 hearing, we don't think that is a supplemental agreement, we're gonna go, we want a full fact-finding, hearing before the administrative law judge, and you cannot let that supplemental agreement. Because we argue it's not a supplemental agreement, I understand the underlying question. That means every time the department, if we rule in your favor, every time the department decides this is an appropriate supplemental agreement, we think it's correcting a rumble strip, we think the microsurfacing was done wrong. In this case, I guess some neighbors decided the strips were too loud, whatever. Every single time the department does that in a state of 22 million people, you get a point of entry.
I guess the corollary to that would be, Judge, if under this agreement, which is now for maintenance of a highway in the first district, they decided, you know what, we want you to build us a bridge in Key West. Well, I think anybody could say, that's not part of this, that's not supplemental, that's obvious. But if you
That's
take
obvious.
away-
That's too easy.
Yeah,
I'm talking
that
about
is easy,
supplemental
but
agreement.
examples, now you-
Excuse me.
Sorry.
I'm talking about supplemental agreements when you're talking about a multi-million-dollar contract. I'm sure, I'm assuming, oftentimes these agreements, these contracts have to be modified because we all know in today's world, there's constant give and take on these kind of construction projects. We went through one here. So you have all kind of give and takes on construction projects, and, you know, you may need supplemental agreements. So every time the department, I'm saying in this kind of situation, every time the department makes, say, a judgment call on what a supplemental agreement is, your argument is a third party has a point of entry, assuming their substantial interests are affected.
If a potential bidder, as we would be here, can say we've been deprived of our right to bid, then yes, they can do that. Do I expect that will open the floodgates in Florida? No, I don't. It hasn't up to this point. The Fairbanks decision is not new.
25 years old.
Yeah, I mean, that's there. It's not going to happen every day. It's atypical. I mean, usually you can see a relationship between a supplementary agreement and a main contract, I don't think people are going to willy-nilly start filing lawsuits challenging supplemental agreements that are valid. And if they're invalid, then they ought to be challenged. And maybe that will compel FDOT or other agencies that abuse the process to start complying with the process. That's what our courts are for. Any further questions? I think we've, gosh knows this has been briefed a lot. I don't want to repeat everything that's in our briefs. I'm more concerned with answering your Honor's questions at this point with the time remaining. Anything? I'll sit down. Thank you, Your Honors.
Good afternoon. May it please the court. Mark Peebles for the State of Florida Department of Transportation. With me at council's table is Rob Vizina. Mr. Vizina represents the appellee Anderson, Columbia. We are splitting our time, probably not evenly. I plan to be here for 10 minutes or so, depending on how hot the panel is. I don't regard the case as particularly complicated. Asphalt Paving concedes that supplemental agreement are not subject to competitive bidding. We know from the USF case, we know from this court's Keystone case, that contracts that are not subject to competitive bidding don't imbue anyone with standing to challenge them. And so the question, the only question that I can see is whether this particular supplemental agreement was properly within the ambit of 337.11.9. That's what you just heard my counterpart say, that what we do challenge is the applicability of 337.11.9 to the work. Judge Jay, I thought your line of questioning about whether we are limited to the four corners of the complaint on standing was well taken. In my view, yes, we are limited to those four corners, but take a look at what the four corners of the amended petition say. The amended petition says that, first of all, the original petition, of course, alleged no issues of material fact. The amended petition alleged, as a question of fact, quote, whether the rumble strip work described in the amended petition falls within the permissible subject of a supplemental agreement under the terms of section 337.11.9b Florida statutes. Questions of statutory and contractual determinations are questions of law, not fact. These are legal contentions gussied up as factual ones. And in my view, there's not a whole lot for DOA to do in this case. DOA is a fact-finding body, and to remand to an administrative law judge to find facts that aren't disputed, the terms of the contract aren't disputed. The language of the statute isn't disputed. It couldn't be disputed. The only question is whether the department was right or whether it was wrong in determining that threshold issue. Is this particular supplemental agreement, does it conform to the terms of 11? Yes, sir.
How would you respond to what we just heard, that there would be testimony, factual proffer related to the types of work that were actually carried out pursuant to this supplemental agreement? How would you respond to that?
The scope of the work is of record as well. I never read the petition as saying that we don't believe that there's a dispute as to what the scope of the work is. They bid on the scope of the work. They know what it is. So it's a bit puzzling to say that there's some kind of question or confusion over or dispute over whether the scope of that work could be. And again, I don't really know what an administrative law judge would do. The scope of the work is going to be what it is, and you could testify. You can adduce testimony, I suppose, that no, I don't agree that that's the scope of the work, but it's going to say what it says. They've argued that the DOT impermissibly reached the merits of the petition when it dismissed the petition for standing.
One more question, and
Yes.
perhaps you misspoke, or perhaps I don't properly understand the record. You said, I thought you said they bid on the work. When did they bid on the work?
Anderson Columbia, I'm sorry,
Okay.
they didn't bid from the DOT. Anderson Columbia sought subcontracting for the work, and they responded. That is in the record.
Correct,
Yes.
but not from the DOT.
No, I apologize for if that, I can see how that was confusing. That was not my intent.
Thank you.
Yes.
Thank you for that clarification.
All right. I believe it was Judge Thomas, you asked what remedy he was seeking. He said, claw back the money and attorney's fees. Neither are raised in the initial brief. The initial brief seeks remand to FDOT with directions to remand for DOA and to order a stay of the work. So first of all, I'm not convinced that DOA could claw back money, and I'm not convinced that DOA could award attorney's fees, but if somebody could, they haven't sought it. And so under decades of precedent, that the remedy that they're seeking here today at oral argument, which is inconsistent with their briefings, that remedy is waived.
What do you think the remedy is that they're seeking?
I don't know. They know now that the work is not only complete, it's paid for. We're not going to unring that bell. DOA certainly is not going to unring that bell.
What do you think the remedy should be, just hypothetically, if we were to hold that they were entitled to a hearing? Is there no remedy, therefore, the judgment should be, the department's decision should be affirmed?
Well,
I know you don't see that there's an entitlement to a hearing.
But I want to understand your hypothetical. Your hypothetical is that the court would find that the department.
Right, I mean, it's not a hostile question. If we hold that they are entitled to a hearing, what could happen at that hearing, in your opinion? Nothing?
If I were an AOJ, I wouldn't know what the AOJ would do. The AOJ would find there's no disputed facts. The AOJ might reach a different legal conclusion than the department reached. But
Yeah, it seems to me the issue is, whatever the work described might be, microsurfacing to placate some folks who thought the rumble strips were too loud. you know, there are a million different variants of that in the world of transportation, I'm sure.
Yes.
So there's no dispute about what that work is, right?
As far as I know, no.
So it's a pure question of law, it seems to me, as to whether or not that fits the exception under the statute, under 33711. Is that not correct?
I agree with you, yes. Yes, and, no, I didn't perceive any hostility.
No, I
in that
know.
question.
So you're saying that the administrative law judge would have no fact-finding. Now, I'm sure on rebuttal, your opposing counsel is going to argue to the contrary, but
I guess what I'm saying is that DOA is spectacularly ill-equipped to deal with this. It's simply not something that the legislature had in mind when it.
well, then how do you read our decision in Keystone?
Keystone's different in that there were apparently disputed facts over whether.
Or wasn't that also a question of whether or not the bidding, I think, of the health services fit the exception under 33711?
According to the Keystone opinion, there were disputed facts. This court specifically said, we won't engage in appellate fact-finding, and remanded to DOA to engage in that fact-finding. This case is different. It's a pure legal question. Does this supplemental agreement fit that statute?
I guess the only time in your view there could be a factual question would be if a party were alleging, oh, you say this is for microsurfacing the rumble strips to quiet them down or whatever, but you're really engaging in a subterfuge and you're trying to do a more major non-exempt contract.
And I'm glad that you used the word subterfuge, because that word was used in Fairbanks. There's no allegation. Oh, I'm sorry, in Keystone. Thank you. That word was used in Keystone. There's no allegation of a subterfuge here. They're simply alleging that we got it wrong, that we tried to put a square peg into a round hole.
So is it your argument then that that would be a 12057-2 hearing where there are no disputed facts?
No, my argument.
The secretary's got to make the decision.
No, my argument is that we determine as a threshold issue, as this court directs us to do they have standing? 120 standing is 120 standing, whether it's.
What if we
informal or
decide
formal.
as a matter of law that it was not exempt?
If you decide it was non-exempt, then under Overstreet Paving, you could remand to the circuit court for award of ancillary relief. If there's no further questions, I'll yield the rest of my time to Mr. Vizina.
Thank you.
Thank you, Your Honors. May it please the Court. Chief Judge Thomas, the questions you asked about essentially the floodgates opening to competitors to attack supplemental agreements is exactly an overarching concern. I know not only of the departments, but of those large heavy highway contractors that do tens of millions of dollars of business with DOT and enter into dozens of contracts with DOT every year. This would be a horrible precedent when any tough competitor could just go out and challenge supplemental agreements willy-nilly to make a point.
What is the recourse in that circumstance? If you're suggesting that they would do it just to do it, what would be the downside? Is there some punitive provision in the rules that would allow visiting some sanction against them for having done what you just suggested could be a problem?
Well, presumably anyone that would bring that type of challenge would be pre-qualified with the department, have a certificate of qualification to bid on department work. Hypothetically, an abuser, I guess, could be subject to the department saying in the annual pre-qualification process, you, Mr. Contractor, have stepped so outside the bounds of proper conduct in our view, and doing business with the department is a privilege, not a right. We're going to deny your certificate of qualification. So presumably, it could go to that extent. And I also want to underscore, and it's been referenced in part, but in Fairbanks and in Fort Howard, the court in both cases made the point that absent extraordinary circumstances, peculiar fact patterns, a non-bidder does not have standing under Agrico to bring a cause of action. A couple of other quick points, and then I'll sit down. The underlying push-button maintenance contract had a line item of work for milling and resurfacing. The supplemental agreement is for milling and resurfacing, to get rid of the noisy rumble strips. Milling and resurfacing at night. All of that work is original work in the 100 or so various work items under the maintenance contract. And you know the nature of these contracts. We talked about it in our brief. They're push-button contracts. The contractor is selected for a year, and then FDOT, when it needs a particular item of maintenance-related work done, pushes the button and says, Anderson, we need milling and resurfacing of the rumble strips down 90 because they're noisy. And that work is performed. And there are thousands, that's not hyperbole, of supplemental agreements entered every year by the Department of Transportation. They award over $3 billion worth of work a year. I don't know how many contracts that encompasses, but I promise you the number of SAs, supplemental agreements, are in that range.
So what do you think is the remedy? Let's say that the question I asked your co-counsel.
Yes, sir.
Or the department. Let's say there's a maintenance agreement for resurfacing a highway, which I assume may involve a lot of intricate tasks related to that. And the department decides, we'd really like to upgrade this surfacing. There's been a new technological innovation, and Anderson, Columbia, or whomever it might be that won the original resurfacing contract. While you're at it, we'd like you to add on this new super duper layer or this new light reflective chemical, or, you know, really improve the project. And it's a $10 million supplemental agreement, if you will. And a party comes in and says, well, we do that line of work, and I'm not casting any bad faith on the department. They might just make an error. And the department says, no, this is just a supplemental agreement with the previous successful bidder, and we're giving this $10 million contract out, and you're out. And they're wrong. Let's just say my hypothetical, they're, you know, under the statute, which has numerous criteria, if you will, as to what is a supplemental agreement, they're wrong. What is the remedy there?
I'm going to add to your hypothetical, and I'm going to assume that disappointed contractor is a non-bidder.
Right.
All right, so I'm not in the business of giving legal advice to APS, but I would suggest that, or in that hypothetical, let's put it, that contractor could go to circuit court and try to seek an injunction. I think that type of thing happens throughout the state, so I think that's the direct answer to your question. The last thing I'd like to make reference to, we filed a notice of supplemental authority today.
If I could come back to
Of course.
Judge Thomas's very good question. Is there an administrative remedy there, hypothetically?
No, I honestly, Judge Ray, I don't see an administrative remedy for a non-bidder in the fact pattern.
Well, that's this fact pattern.
Right.
That's our case. I mean,
Yeah.
that's a party saying, no, I'm somewhat perplexed as to whether it's a pure question of law or not, but you mistakenly defined the scope of this as a supplemental agreement, and it's not. And I'm not sure that requires an administrative hearing or is strictly a pure question of law that the secretary rules on and is subject to appeal as a matter of standing, I assume. But, and take the time you need to collect your thoughts.
Yes, I appreciate that.
We'll give the appellees an additional 2 minutes and the appellant an additional 2 minutes.
Just to wrap up my thoughts on that, no, I do not believe there's an administrative remedy. I believe there's a state court remedy potentially available in that situation. And I do believe also that this is a question of law, given the way APS framed its petition. The last point I wanted to share with you, Your Honors, we filed a notice of supplemental authority today, the Leach Wells case. It's a sunshine law case, but here's the relevance. The underlying sunshine law case was brought against the city of Bradenton, and the plaintiff said, out of the sunshine, the city of Bradenton shortlisted contractors for this new project and ultimately selected a contractor, and that was done in the shade. It should have been in the open. Plaintiff tried to get an injunction. Injunction was denied. It's on the trial calendar. In the meantime, the city of Bradenton picks the contractor off the short list, builds the project, goes to the second DCA. The second DCA says, the trial judge's finding at trial that there was no sunshine violation was wrong. There was clearly a sunshine law violation. But the case is moot because the contractor was contracted with and the project was built and it's done. And on that basis, on the finding of mootness under those facts, the court affirmed the underlying judgment. Thank you, Your Honors.
Thank you.
A few responses. As to the fact issue, one of the things we've heard over and over is that this is the same work, it's milling and paving. Well, there are real issues as to whether micro-servicing constitutes paving. There are new line items in the supplemental agreement that were not included in the maintenance contract, and I think it requires a fundamental understanding of the difference of these processes to determine whether it is in fact the same work. We've alleged this is new and different work, that the paving contemplated in the agreement and that being paid for under the supplemental agreement, as evidenced by the fact that there are different pay items, is in fact a different item of work. That is a fact issue. Another fact issue is, were these rumble strips, as Anderson contends, part of this contract, or were they done previously under a different contract? That is a huge issue. Now, the fact that it's finished work, I would go back to what the statute tells us. What the statute tells us is if that work was done, it is null and void. The contract, if impermissible as a supplementary agreement, is null and void, and payment is void. Now, in our, I guess we're kind of being held to a different standard because as this case progressed, things happen on the ground. I mean, they did finish the work. So yes, the facts were different at the time we pled. Intervening events happened. They did the work. We addressed that in our initial brief, and we said, okay, they did the work, don't pay them. That was in our reply brief. Well, they paid them. Now, I come back to, how does the law treat that? Do they say, well, it's inequitable to call that money back? Well, I don't.
Well, your
think it
argument is we don't need to address that, right? That's getting to the merits of the
Correct. First and
petition.
foremost is standing, but I think
Right.
in large measure, my adversaries have addressed really this is the same work and talked about merits when really today's focus ought to be on standing. There was a question of whether we were a bidder, and that's talked about in other cases, Keystone. In this paradigm, there are no bidders. There can never be bidders to challenge. That is a fact. So if you preclude folks like us from having standing, no one could ever challenge it. Basically, FDOT has given themselves the imprimatur to do a supplemental agreement whenever they want, wherever they want. I use the far-fetched example of building a bridge in Key West. Well, that's not really far-fetched to the extent you say you don't have standing if you're not a bidder. Nobody
Well, now, by
has-
definition, the issue involves non-bidding parties. It's
Excuse
the
me?
department deciding that the agreement is a supplemental agreement, not subject to competitive bidding. And a third party like yourself coming in and saying, yes, it is, right? That's what this case is.
That's what this case is.
So,
And the question is, do you allow folks to do that? Or do you say what FDOT says goes and cannot be challenged by anyone? That's really what it comes down to. And I think the risk incumbent in saying no one can challenge this, or saying, gosh, maybe a lot of people will challenge this, I think better under the state's strong public bidding policy to allow people to challenge. And I think soon enough, either FDOT will change its ways if they are in fact wrong. Alternatively, folks aren't going to spend money doing what we're doing if they're going nowhere with it.
well, I think that's a legitimate question here, and that is, in a state of 21.3 million, I think it is, with, billions of dollars worth of contracts being executed, a statute designed to make the department's actions fast and effective, responsive to changing conditions. And 337 doesn't have, as I recall, any specific language saying, and by the way, if the department makes a mistake in deciding this is an exempt supplemental agreement, you can challenge that in a 12057.
Well,
So what you're asking us to do here, and it's not out of line with what we said in Keystone, but it does pose some, I think, some significant public policy questions.
I would say in terms of public policy, one, if we look at the focus of 337, the focus is not what are the exceptions, the focus is on what ought be the rule, the standard. And we know the standard, if it's over $250,000, it ought be bid. So they've carved out some exemptions, and my guess is 99% of the time they use those exemptions, it's appropriate. This is a time where it's inappropriate. And I would suggest that the fact that that very same section says that if such a contract is let, it shall be deemed null and void and no payment made. And first, somebody has to be able to challenge it. The contractor that got the award isn't going to say, don't pay me, nor is the state. So who's going to exercise that? If not somebody that was aggrieved by the decision to make the supplemental agreement in lieu of putting it out to public bid. And the fact that this is such a big state and does have such a strong policy towards public bidding, I think advocates strongly towards having things open, public, where things may be inappropriate, having them challenged in a public forum, and not just signed off by DOT saying, because we
Now
say it's
you're in
this.
excess of your time. Would you like to conclude?
Yes. Your Honor, I have nothing left to say.
Thank you. Thank you. The court will be in recess.
All right.